Welcome to our Curious Amalgam, the weekly podcast brought to you by the Antitrust Law section of the American Bar Association. Our Curious Amalgam explores the fascinating and increasingly overlapping world of competition, consumer protection, data protection, and privacy law. Each week, we bring you leading global experts on the most compelling issues of the day. Enjoy the show.
Welcome to our Curious Amalgam. I'm Jaclyn Phillips, and the title of today's episode is Should We Bank on Changes? A conversation about bank merger policy. In this era of increased enforcement and focus on the risks, if any, of increased consolidation, few industries are safe from scrutiny. While the banking industry was one focus of President Biden's 2021 executive order on promoting competition, bank failures that occurred in mid-2023 have brought the banking industry to the forefront of the conversation, leading to debate about whether changes are necessary. In June 2023, AAG Cantor stated that the time is ripe for the division to revisit the bank merger guidelines and make sure that the legal principles of 1963's Philadelphia National Bank are being applied in a manner that is consistent with modern market realities. On today's episode, we will discuss both sides of the debate about bank consolidation, the division's approach to bank mergers, and the division's recent comments on an updated approach to bank merger review. Joining me today is my co-host, Sergei Zaslavsky. Hey, Sergei.
Hey, Jaclyn.
So can you tell us about our guest and kick off the conversation?
Sure. Well, we're very fortunate to welcome one of the leading antitrust practitioners on bank mergers, Wachtell partner Damian Didden. Welcome to the program, Damian.
Nice to be with you, Sergei and Jaclyn.
So, banking sector has been in the news quite a bit this year, with some high-profile bank failures, including Silicon Valley Bank and First Republic Bank, among others. How did this instability in the banking sector affect the ongoing debate over bank consolidation?
Yeah, I think it's an interesting question, Sergei, mostly because the effort to sort of redo the bank merger guidelines long predates these recent bank failures. Right. I mean, the pending revisions to the bank merger guidelines have been pending for almost 3 years at this point. When DOJ first asked for comments, and we submitted our comments, I think, in October of 2020. And so there's sort of this just long pause that's gone on since people have submitted comments, and it's hard to know why this is taking so long, other than the fact that it's very complex. To sort of come up with a guiding policy that's different from what we already have. And my gut feeling is that there's probably disagreement between DOJ and the bank regulatory agencies who jointly issue these guidelines. And so, yeah, the recent bank failures obviously have put a spotlight on the banking industry. I mean, personally, I don't think they have much to do with the issue of consolidation in any way. They really have much more to do with sort of, changes to interest rates and the fact that these banks were caught with a new, environment on interest rates that put stress on them. I think that some have sort of opportunistically said, right, that this is the result of some sort of consolidation. But I really don't see that there's an empirical relationship between those two things. But you're right. There's now a spotlight on this issue for sure.
Yeah, so this debate's been going on for a while, as you said, about whether there is too much consolidation in the banking sector or whether that's not a problem. And could you just sketch out the two sides of this debate for our listeners? What are the folks who are worried about consolidation saying, and what are the folks that think consolidation is fine and not an issue are saying?
Yeah, so I think if you look at our banking sector in this country, and just to sketch out the sort of state of play, we have over 5,000 banks. We have other non-bank institutions that function a lot like banks, so thrifts and credit unions and savings and loans. And then we have this whole area of fintechs and others who are sort of encroaching on what used to be kind of banking space. But the 5,000 bank competitors we have are all fully regulated. And I think if you look at countries around the world, they're sort of surprised that we have that many banks and that we have this sort of fully regulated banking sector with that many independent competitors. And it's hard. I'd be hard pressed to think of any other industry, frankly, that is really, that sort of unconcentrated. And so if you look back to the history of banking, right, there were 14,000 banks in this country at one point. And people who are concerned about consolidation say, well, we've gone from 14,000 to 5,000. Isn't that a problem? Well, the history of banking is somewhat unique because there were regulatory constraints in place against interstate banking. And so every state and every locality kind of had its own bank, and they kind of grew up from the grassroots level. And that was great, but it was highly inefficient. And Congress sort of recognized that inefficiency, and beginning with sort of bank reciprocity agreements, banks sort of crept into the interstate world. And then finally, with the Regal-Neal Act in the 1990s, interstate banking was permitted, and the gloves came off. And you saw this wave of consolidation as a result, most of which was pro-competitive in that it allowed some banks to enter new areas where they couldn't be before. And it allowed banks to achieve efficiencies that they couldn't have before. And so I think on one side of the debate, you have people saying, well, there's this is apparent massive consolidation. We're nervous that, community banks are being squeezed out. And then on the other side, you sort of have people scratching their heads when they're looking at a very diverse banking sector and saying things have never been more competitive before. So that's my take on it anyway.
So just to put a spotlight on a couple of the arguments that I hear in this debate, some people raise the concern about local banks that you mentioned and say, well, local banks are better at serving small local businesses than large national banks. And so if small local banks go away, that may make it tougher for local businesses. Do you think that's a serious issue? What's your take on that particular issue?
Well, I come, Sergei, and I don't know whether you know this, from a community banking family. My family has run a local community bank in Washington, D.C. for over 100 years in the Capitol Hill neighborhood. And my father was the epitome of a community banker. If you've seen that movie, It's a Wonderful Life, his name was George, but he was a lot like George Bailey in that movie. And he would walk down Pennsylvania Avenue and all the merchants would know him. So I have and I worked at the bank, for summers since I was 12 years old as a bank teller, rolling coin, working in the bookkeeping department. So I have a pretty intimate understanding of how community banking works and its benefits to the community. And they are legion. And I think that the people who think that community banks serve their communities well have it exactly right. They do, and they're very important. We're not seeing consolidation having real effects on that, however, at the community banking level. The stresses on community banks are not coming from consolidation. Yes, they have to compete with now a whole host of enterprises, including big banks that can offer products they might not be able to, including technologies that are coming from all sides, from all sorts of players, and then including a giant regulatory burden now, where if you don't have a certain scale efficiency, you don't have the ability to manage this sort of regulatory infrastructure that you need to be a bank. So I don't know that there is a crisis in community banking at the moment. I think what's more likely to happen is that banks are going to try to achieve a certain size to reach efficiencies. And if anything, under the banking regs, that when you reach a certain size, and I forget exactly what the cutoff is, whether it's 10 billion or something like that. What I'm more concerned about is we're going to see a barbell where you're going to have really large banks at one end. You're going to have community banks who are sort of under this, regulatory threshold at the other, and we're working on sort of hollowing out the middle. To me, that's a much larger concern than the idea that community banks aren't able to compete, because I think they compete very well on a relationship basis.
Very interesting. Another concern that I hear expressed in this debate is the whole too big to fail concept. The idea that we have consolidation, then we have even larger big banks. And then when those big banks get in trouble, the government's kind of on the hook to bail them out because they're systemically important and too big to fail. And the idea that a banking consolidation makes that problem even worse. What's your response to that concern?
Yeah, so the largest banks in the country aren't really able to merge. We have a 10% deposit cap, a national deposit cap in the country, and there are various state deposit caps that come into play as well. And so banks that are already quite large within their states are kind of prohibited from merging on the basis of their state deposit cap. And the largest national banks, right, the big money center banks, really can't acquire any other banks because they're already over the 10% threshold. So what does that mean? So you've got these large banks who are already systemically important. And then you have sort of, this sort of next level of regionals or sub-regionals, right, who are trying to do things like expand into new markets and trying to find efficient ways to operate, to compete against these large banks, as well as getting pressure from the community banks, right, who are sort of eating their lunch in local areas. And so they're sort of left scratching their heads on how do we achieve that easily and efficiently, in an era where people say we can't merge. So I really don't. I think the too big to fail and the sort of systemically important debate is in a lot of ways different from what we worry about with antitrust. I don't think that kind of concentration of the financial sector. And this is the kind of a unique thing about banking, right? But banking is so central and important to our economy in so many ways that it is regulated, right? We're talking about a very regulated industry with the Fed, with the FDIC, with the OCC. So antitrust's role here and sort of purview, I think, is somewhat limited. And the question about too big to fail and systemically important really is a sort of more philosophical question for the banking regulators than it is for antitrust.
Well, now that we covered the big picture debate on bank consolidation, let's dive in and talk a little bit about the actual tools and policies for reviewing bank mergers. Could you briefly summarize for our listeners how antitrust review of bank mergers is different from merger review in other sectors? And I should mention also for our listeners, if you are interested in this, you should also go back and check out episode 143 of our Curious Amalgam, where we cover this topic in quite a bit of detail. But on the off chance that not all of our listeners have our whole back catalog memorized, why don't we provide a quick summary here as well?
Well, I'm happy to provide a summary, and I endorse people going back and listening to David Neal, who was my former partner and my great mentor and one of the great minds of banking antitrust who's ever lived. So definitely well worth a listen. I think, Sergei, yeah, the bank merger process is very different from other industrial merger review, principally because HSR doesn't apply to bank mergers. And so you're in this kind of other realm where you're dealing with whichever bank regulator might apply, so the Fed or the FDIC or the OCC, and then under a statute called the Bank Merger Act or another one called the Bank Holding Company Act, DOJ plays a consultatory role. And so DOJ gets notice of the transaction and then has to provide a report on the competitive issues to the agencies who make a final decision. And in banking, those agencies, unlike HSR, which is a clearance process, the bank agencies actually have to make an affirmative approval. And so, and there's no official timeline for DOJ or its report. And so there's no clock like there is in HSR. And so the way things had worked for a long time was DOJ would, separately investigate, and they use very different criteria in some instances than the banking agencies. And both have to be satisfied. And so you end up having to sort of triangulate and solve by remedying what we like to call to the highest common denominator. So in other words, it's not that one undercuts the other. You really have to solve both. And often they use different criteria. And we can talk about that, or you can listen to David Neal and learn more about that. But DOJ's role, it really is a consultative role. That they're the ones in charge of the competitive issues, and they need to be satisfied that a transaction is not anti-competitive. But the bank regulators have to make an affirmative decision about a deal more holistically based on their criteria for safety and soundness and convenience and needs and a host of other community factors.
So as an antitrust lawyer shepherding a bank merger, what's the split in terms of how much you engage with the DOJ or how much you engage with the banking regulators?
That's a great question. It used to be much more 50-50 that you would sort of engage with the Fed and their economists and you would engage with DOJ. And let me just say about the DOJ investigators, they are incredibly seasoned and incredibly well practiced. There is such good institutional memory within the staff at DOJ who reviews bank mergers, and they have such a smart way of going about this. And they look at every issue. I mean, they're not so. Just to give you one example, the Fed defines its own geographic markets. And you sort of do your analysis within those geographic markets that the Fed has already figured out. At DOJ, they're not bound by that. And so you end up in a debate with DOJ, just like you would in an industrial merger over the size of a geographic market. And that's how you can come to different outcomes with the two regulators. And what happens is every time there's an administration change, these staffers at DOJ who are truly, at the top of their game end up having to re-educate all of the new political appointees who come in. And you almost never want to be the first bank merger because you got to go through this whole education process all over again, rather than them just being able to trust the staff and the excellent work that they do.
That's interesting. So I know that a couple months ago in June 2023, DOJ Antitrust Section Chief Jonathan Kanter announced some pretty significant changes to the banking merger review process. Can you summarize some of the relevant changes he announced in his speech?
Yeah. Yes. I mean, it was an interesting speech in a lot of ways, but let me give, I think, some context for it. There has been a lot of political saber rattling and a lot of political pressure on DOJ and on the bank regulators over bank mergers. And this is primarily coming from Senator Warren and a few other areas. And the words they keep saying are, the regulators are rubber stamping bank mergers. And they love this talking point that, a bank merger hasn't been blocked in 30 years. Well, it's kind of a nonsensical idea that a bank merger would be blocked. Again, this is an affirmative approval process by the banking agencies. They don't have to block anything. And then if DOJ were to disagree, they have an automatic stay in federal court to sue against a deal. So there's no bank merger that's ever going to go to court against DOJ. And what happens as a practical matter is you settle and you divest bank branches, and banks buy and sell branches all the time. So this is a very well-trodden remedy path. Or you abandon. And if DOJ, you can't satisfy DOJ, you walk away from the deal. And so this idea that somehow regulators have been lax, right, and they haven't been doing their job, and they've been asleep at the switch, and they're a rubber stamp, is kind of the pervasive mentality that we're hearing out of the most vocal politicians. So Kanter's speech, I think, is in the context of that, and what he's saying is basically, look. We're going to take charge. We're going to revamp the way we do mergers, and we kind of expected him to announce something about the revised bank merger guidelines at this speech, and yet there was nothing. And so this 3-year process that's been pending on announcing the bank merger guidelines, we thought this was the big denouement, and it was kind of an airball. And so instead, we got a lot of generalities out of Kanter and talking about sort of new theories and new ideas about how to analyze bank mergers, and saying we're going to slice and dice them, 6 ways to Sunday. Well, I mean, DOJ staff already looks at all of the markets and products in banking. And he kind of nods towards fintechs and says, we're in a whole new era. But he doesn't say whether he's going to factor those in as, a mitigating factor in terms of competition. And so we're left with a lot of questions and not a lot of specificity out of Kanter's speech, other than we know, right, that there's an animus, that there's something there, which means that they're going to take a different approach. We just don't know what that approach is.
So it sounds like a lot of open questions, a lot of generalities. So practically speaking, are there any implications that banks considering a merger can take away from what we heard from Jonathan Kanter?
Well, I think there was one point that was particularly interesting to me, Jaclyn. It was when he said that DOJ is going to effectively absent itself from remedy discussions. So the way things have historically worked is if you want to get a deal approved and you have some concentrated local markets, and bank deals are analyzed on a local market basis as well as on middle market and sort of more regional basis. But to solve local market cases, you would often have to divest branches or lenders or something, and you'd have to satisfy the Fed and DOJ. But DOJ would take charge of that process, and you'd enter into effectively a consent decree, although it's not driven by a court. It's a letter of agreement with DOJ about what you're going to do and what you're going to divest. And then you go sign an upfront buyer. All bank deals require an upfront buyer. But Cantor is saying in his speech that DOJ is no longer going to do that. And that they're not that they're going to issue their report to the federal agencies, but they're not going to engage on remedies. So what does that mean? Does that mean that the Fed or the OCC or FDIC could approve a bank deal and DOJ could later sue it in court? It feels odd, but that's kind of what he's saying. And so it's this sort of saber rattling. Is it saber rattling? Is it something more than that? Why would this move, which vastly decreases transparency, right, be something that's beneficial to our economy or to consumers? It's really hard to understand. And so as a practical matter, what do we take away from this speech? More investigation, longer time to look at things, being prepared to, make your case across a whole spectrum of brand new ideas, things like that. But in terms of, actual guidance, I think there's very little here.
One thing that caught my eye when I was reading the speech, I had a question about, is Cantor mentioned that DOJ will look into interoperability and multi-market contacts in assessing competitive effects. What do you think he means by that? And what do these concepts mean as applied to banking mergers?
It's a great question, Sergei. And I don't think we really know. I do think interoperability, I suspect, is part of the larger discussion around interoperability and customer data. And I don't really think of bank mergers as having much of an effect on that. But I suppose theoretically you could look at whether banks are restricting fintechs or others who, use bank customer data in order to run their businesses. So in other words, if you think of a Venmo, for example, right, where you're sending money to somebody out of your bank account, well, Venmo has to interact with your bank in order to get that data. Is there some theoretical possibility that a merger would reduce the interoperability? I mean, I suppose there is, but it seems like a very tertiary kind of idea when you think about, traditional bank mergers. And then this notion of multi-market contacts, I think is really kind of left field. I mean, the theory, as I understand it, and I'm not sure I completely do, but I think it's the idea that if I'm going to move into some new areas as a result of a merger, right? So let's say I'm a bank and acquiring another bank, and we don't have any geographic overlap. Traditionally, that was sort of viewed as pro-competitive or at least not anti-competitive because we don't compete in these geographies. But the idea of multi-market contacts is, well, what if I'm seeing the same competitors now in more markets and thereby gathering more market intelligence about how they operate and how they price? And is that going to redound to my ability to price differently in non-competitive markets, right? I think there are so many elements to prove a case there that, I'm not an economist, and I know you aren't either. I think you'd have to really spin through some deep, deep economics in order to build a case if you're DOJ on that front.
So it sounds like another area where we may be left with more questions than answers coming out of this speech.
Yeah, I think that's sort of how this speech is. And in some ways, I almost wonder if it's designed that way, right? If it's designed to sort of create optionality rather than transparency, which is what traditionally guidelines have done.
Another leitmotif in the speech that really stood out to me is the idea that a lot has changed since 1995, when the last bank merger guidelines were issued. And I guess if this speech is a lead-in to the new guidelines, then that's a theme that makes sense. A lot has changed. It's time for new guidelines. But what are the changes that Cantor highlighted as being important? And do you think there are other changes that maybe he did not highlight that are also important to keep in mind?
Well, again, it's hard to know from his speech exactly what he believes is important or not. In terms of the last guidelines and changes that have occurred since then, when the original bank merger guidelines came out, they were more relaxed than the original horizontal merger guidelines because there was this recognition that, we have very limited data sources in banking. We have deposit data. We have Community Reinvestment Act data on small business lending. But apart from that, it's really difficult to get your arms around some kind of systematic data that allows you to do competitive analysis. But there was this sense that banks face competitive pressure from mortgage companies, from a whole host of suppliers that are non-banks that weren't captured in the data. When the 2010 merger guidelines came out, not bank merger guidelines, but merger guidelines came out, they kind of flipped that a bit, and suddenly the bank merger guidelines were now more restrictive than the industrial merger guidelines, without any explanation or justification. And so only because the bank merger guidelines hadn't moved. But if you look at the trends in the industry that have happened over time, I mean, again, there's these people who use these talking points about consolidation, but to my mind, it's never been more competitive, the banking sector. I mean, think about how you bank now. When's the last time you went to a bank branch or a bank teller? Now in the era of remote deposit capture, if somebody sends you a check, and by the way, people aren't writing checks very much anymore, but if someone sends you a check, you take a picture of it with your phone and it's deposited to your bank. Doesn't that mean you could bank anywhere? I mean, I'll put it this way, that small community bank that I work for in Washington, D.C. has been my bank my entire life since I was 12 years old. And I've lived in New York for the past 22 years. So the idea that somehow there's this way in which banking has become less competitive in the era of the internet and the era of fintechs, when everybody is trying to disaggregate every single aspect of our financial lives, I think has to be accounted for, and yet it isn't. And to me, that's the most significant change, and the change I would love to see in the new merger guidelines.
Well, I guess we're all left waiting breathlessly for the new bank merger guidelines, since a lot of questions right now, and Cantor's speech provides not that many answers, as we've explored.
Don't hold your breath is my advice, Sergei.
Well, actually, why don't you elaborate on that? Why shouldn't we hold our breath?
Only because we've been waiting now for close to 3 years, and while we hoped that Cantor would sort of give us some guidance at that speech about timing, it wasn't even mentioned. So instead, we're sort of left in this limbo about when and what they're going to look like.
Well, we'll see when or if they come out, and then maybe we'll have to have you back to discuss the guidelines at that point.
That would be my pleasure.
Great. Well, thank you, Damian. And it's great to be able to talk to somebody with not just a professional, but a personal connection to the banking industry to understand these issues. And before we let you go, we have a personal question we ask everyone. And you can't answer with, I come from a banking family. So
I'm ready.
What is something we would not know about you if we only knew professionally?
All right, so I'm gonna answer with two things. One of them is that I'm an avid birder and outdoorsman, and I love going to the woods, and I like. Speaking of my father, he was a birder, and I inherited his binoculars, and I carry them with me. So I turn to nature to de-stress from work and to commune, and birding is one of the ways I do that, and I really love it. And the second one would be that I came to the law from a theater background, and that my wife and I met on the stage of our high school musical theater, where she was Dorothy and I was the Tin Man. So don't say Oz never did do nothing for the Tin Man.
I love that. Those are both excellent facts.
And now it's time for the Curious Hat.
So, Damian, pick a number from 1 to 15.
Let's go with 12.
All right. What book are you reading right now?
Well, it's a great question. So I have it here. It's called, and it's actually a book my daughter was assigned. She's going into her senior year in high school. It's called Survival of the Sickest. and it's by someone named Dr. Sharon Moalem, and it's about the interesting developments in epigenetics. So that's what I'm reading right now.
I would think that you knew the question in advance and had that book planted right there, but I know better. So
Surprised there wasn't anything about banking mergers.
Sergei, even I need to decompress sometimes.
Yeah. You can only love banking mergers so much, I guess. Well, thank you so much. And thanks to our listeners. We'll see you next time on our Curious Amalgam.
Thank you for listening to this week's episode of our Curious Amalgam, a competition, consumer protection, data protection, and privacy law podcast. It is produced and shared around the globe by ABA's Antitrust Law Section. The opinions expressed by the participants in this podcast are their own and do not necessarily represent their employer or other organizations. If you like what you heard or would like to become a member of the American Bar Association, please check out what the Antitrust Section has to offer at ambar.org/antitrust. You can learn more about our podcast at ourcuriousamalgam.com. If you have comments, suggestions, or podcast ideas, please reach out to us at podcast@ourcuriousamalgam.com. Until next time, thank you for listening.